Now let's talk about the law of security with theme 2 unit 1. So what is a suretyship contract? Well, it's an accessory contract where the surety agrees with the creditor that the debtor will perform their duty to the creditor in terms of their agreement, and that when the debtor fails to do so, the surety will perform this duty or indemnify the creditor. So what are the 5 stages a suretyship agreement comes into existence? Well, the first stage is that the creditor and the principal debtor conclude a contract. The second stage is that the creditor needs security that the debtor should pay. The third stage is where the creditor enters into an agreement with a surety to pay the creditor if the debtor fails to do so. Then the fourth stage is where the debtor fails to pay the creditor. Then the fifth stage is where the creditor calls on the surety to pay for the debtor. Let's talk about the nature of the suretyship contract. Well, the suretyship is accessory to the principal debt, and therefore it's dependent on the existence of a debt. And then in forms of the formation of a suretyship contract, the suretyship is a consensual contract between the creditor and the surety, and all the requirements for a valid contract should be complied with. The suretyship contract should mention the identities of the creditor, debtor, and the surety, the nature of the secured obligation, and the extent to which the debt is secured. But then what are the consequences of suretyship? So the first benefit is the benefit of execution. So the surety may insist that the creditor first demand performance from the debtor before claiming performance from them. Then we have the benefit of division. So co-sureties are liable jointly and severally for the whole amount of the principal debt. Then we have the benefit of cession of actions. So the right of the surety who has paid the debt to recover the amount of interest paid or legal costs from the debtor or co-sureties. Then we have the right of recourse against co-sureties. So a surety who's paid the debt has a right of recourse against the principal debtor. Then we have the right of recourse against principal debtor. So the surety who's paid the debt is by operation of law entitled to claim the amount of their performance from the debtor. And then what marks termination of suretyship? Well, it's payment of the debt and performance by the principal debtor. Now we move on to mortgage, pledge, and cession and security with theme 2 unit 2. So what is real security? Well, it's a right that one person, the creditor, has in respect of movable or immovable property of another, the debtor, in order to secure the performance of an obligation. So the advantage of real security to the creditor is that on default, they may get an attachment order and satisfy their debt from the proceeds of the sale of the object. So real security originates from an agreement between the creditor and the debtor or by operation of law. So what are the general characteristics and requirements of real security? Well, a principal debt must exist. Both the pledge and mortgage are founded on an agreement. Only the owner of the thing may pledge or mortgage the thing to a creditor. Anything that has an economic value and can be alienated may serve as real security. And as long as the debt hasn't been paid, the whole of the subject matter remains subject to the real right of security, and the real security only terminates when the debt is fully paid. But then what are the consequences of real security? Well, in the event of non-payment by the debtor, the creditor may have the object sold in execution, and in the case of the debtor's insolvency, the secured creditor has a preferent right to the proceeds of the object as opposed to the unsecured creditors. And now let's talk about the termination of real security when it comes to an end. Well, it's by performance or satisfaction of the secured obligation or debt, when the period for which the security was granted expires, or when the pledge or mortgage agreement is terminated by order of the court. So now we move on to pledges. So what is a pledge? Well, a pledge is a limited real right that secures a debt owed to the creditor by placing a movable object of the debtor in possession of the creditor. And only movable property, not immovable property, can be pledged. And the parties to a pledge are called the pledgee, so the person to whom the pledge is given, and the pledgor, the person providing the property as security. And it's essential that the parties agree that the pledged object will be delivered to the pledgee. Let's talk a bit more about the agreement to pledge. Well, the pledgor and pledgee should conclude an agreement to bring about security. The law prescribes no formalities for the conclusion of this type of agreement, but the parties themselves agree on the formalities for the validity of the agreement. So the pledgee has no real right in the pledged item unless and until they're placed in possession of the object by delivery. And once the pledged item is in the possession of the pledgee, the asset isn't for the use and enjoyment of the pledgee, but rather as a form of security against the obligation of the pledger. So now let's take a look at some of these standard clauses often incorporated in the pledge agreement. So the first one we have is lex commissoria. Here, parties must agree that when the debtor defaults, the pledgee may take over the property at fair value. The next clause we have is the use and enjoyment of the pledged object. So this entitles the pledgee to use and enjoy the object as well as its fruits, often used as a substitute for the debtor's interest liability. So the pledgee isn't entitled to use the pledged object in the absence of such an agreement. The next clause we have is summary execution. So parties may agree that the pledgee may sell the object without the formal sanction of the court and satisfy their debt from the proceeds. But now let's take a look at the contents of the real right of pledge. Well, the pledgee may keep the object under their physical control until the debt is paid. The pledgee may single out this object for purposes of execution after getting judgment against the pledger on the principal debt. The pledged property doesn't form part of the insolvent estate of the pledgee. Upon the insolvency of the pledger, the pledgee has priority over other creditors in respect of the proceeds of the pledged object. So what is the duty of the pledgee? Well, the pledgee is required to take proper care of the pledged object while it's in their possession. Now we move on to mortgages. So what is a mortgage? Well, it's when a creditor obtains a real right over immovable property of the debtor in order to secure payment of a debt owed to the debtor, or where a borrower or mortgagor can offer their immovable property to a lender, mortgagee, as security for the repayment of a debt. The mortgagee, usually a bank, will cause a mortgage bond to be registered over the immovable property as security for the fulfillment of the mortgagor or the borrower's obligations. So the mortgagor is the individual, company, close corporation, partnership, or trust who has borrowed money to finance the purchase of an immovable property and mortgages their property as security for repayment of a loan. And then the mortgagee is the bank, financial institution, employer, or individual who lends money to the mortgagor and in whose favor the mortgage bond is registered. So what about the agreement to mortgage and registration? Well, parties must agree on the contents of the debt, for example, interest to be paid, place of payment, etc. And they must also agree on the mortgage bond. But then what is a mortgage bond? Well, it's based on an agreement in which the mortgagor borrows money from the mortgagee and agrees to pass a mortgage bond over a specific immovable property in favor of the mortgagee as security to the mortgagee for repayment of money. So what are some of the rights and obligations of the mortgagor? Well, they have the obligation to actually repay the loan. That said, they also have the right to use the property. So the mortgagee or the lender doesn't obtain the use and enjoyment of the mortgaged property as it's retained by the mortgagor, the borrower, subject to restrictions. For example, maybe they'll say you can't rent it out or something. And then mortgagors or the borrowers also have the right to sell and transfer. So the mortgagor can't transfer the property unless the mortgage debt has been paid in full and the bond's cancelled, or the land is released from the operation of the bond with the written consent of the mortgagee. So what are the types of bonds we have? Well, we have a special bond over specified immovable property, and then we have a custings brief bond. So this is a type of bond used to secure the purchase price or balance of a property when a purchaser is unable to get financing from a financial institution, and is registered simultaneously with the property transfer and provides security to the party that has advanced the money. So advantages of using a custings brief bond include the opportunity for a purchaser to buy a property without loan approval from a financial institution, the ability to negotiate the interest rate, preferential claim for the mortgagee in case of the purchaser's insolvency, and the possibility of being registered as a first bond. However, the mortgagee may need to become a registered credit provider, and the seller may experience frustration due to delayed receipt of the full purchase price. And then another type of bond we have is the kinderbewijs bond. This is where the surviving spouse, as the natural guardian of their minor child, is entitled to receive any sum of money due to that child from the estate of the deceased spouse, provided that the sum has been secured by a mortgage bond in favor of the master of the High Court. And then another type of bond we have is a covering bond. So this is a bond that's granted to secure a debt which didn't exist or part of which did not exist at the time of registration of the bond. And then the last type of bond we have is bond over immovable incorporeal things. Another specific type of bond we have is a notarial bond. So this is a bond registered over specific movables, all the movable things, corporeal and incorporeal, belonging to the debtor or third person. So should the debtor default on their obligations to the creditor, the bond enables the creditor to have the hypothecated assets attached and sold to satisfy their claim against the debtor. So a notarial bond may refer to a specific movable asset or assets of a debtor, known as a special notarial bond, or it could refer to all the movable assets of a debtor, known as a general notarial bond. So a notarial bond must be lodged for registration within 3 months of its execution. Now let's talk again about cession in security. So this is where a debtor cedes to a creditor certain incorporeal personal rights to secure the repayment of a debt. For example, insurance policies and shares. So this type of security is created by way of an agreement between the debtor and the creditor. So security by cession may take one of two forms. First, a complete cession where the parties agree that the debtor transfers their personal right to the creditor on condition that the creditor will cede back the personal right to the debtor after payment of the debt. Or it can take place by way of a personal right where the principles of the pledge are applied. So it's important that the parties express their intention clearly with regard to the type of cession they prefer. Now we move on to hypothecs and liens, theme 2, unit 3. So what is a tacit hypothec or landlord's hypothec? Well, it's a common law protection remedy landlords can use to collect rental arrears from tenants. So the remedy allows a landlord to sell the tenant's movable goods that are on the leased premises if the tenant fails to pay rent. And the landlord can obtain a court order to attach movable goods to recover the unpaid rent. And the hypothec comes into effect by operation of law. Now let's take a look at some of the properties subject to a hypothec. So it includes all movable goods which are owned by the tenant and are present on the leased property. So these are all subject to the landlord's hypothec. And movable goods belonging to third parties which are present on the leased property are also subject to the landlord's hypothec, provided the following requirements are met. So first of all, the goods mustn't be on the property for temporary use, and the goods must be on the property for the use of the tenant, and the landlord must have not received any notice that the goods belong to a third party, so they shouldn't know. And the goods must be on the property with the knowledge of the owner of the goods, and the goods must not be the subject matter of a credit agreement. So where the landlord is aware that specific goods belong to a third party, or where the tenant has previously notified the landlord that specific goods do not belong to them, the landlord won't enjoy a hypothec over those goods. So but when does the hypothec take effect? Well, the hypothec theoretically exists from the date the tenant occupies the leased premises. However, it only becomes legally enforceable when a court order is obtained. Now let's talk about liens. Well, what is a lien? Well, it allows the person who has incurred expenditure or spent money on someone else's property to retain that property in their possession until they've been compensated by the owner for what they have spent on that property. And it arises by operation of law. For example, if John's the owner of a damaged truck, and let's say he brought it to Jeff's workshop for repairs, Jeff has the right to withhold the truck from John until he pays for the repairs. So a lien's purpose is to secure the repayment of money or labor that the lien holder has spent on the owner's movable or immovable property. It operates as a defense to the owners, re vindicatio, and entitles the lien holder to retain possession of the property until compensated for the expenditure incurred. So as soon as the lien holder's claim has been paid, the lien terminates automatically because it's accessory to the principal debt. So what are the types of liens? Well, we have debtor and creditor liens. So the creditor and the debtor agree that the creditor will incur certain expenses in respect of a thing belonging to the debtor. The creditor is entitled to keep the thing in their possession until the remuneration agreed on has been paid to them. For example, a contractor, which is the creditor, who's been contracted to build your house, has a lien over the house until they're fully paid by you, the owner or debtor, in terms of the contract. So another type of lien we have is an enrichment lien. So enrichment liens allow a possessor to claim expenses for necessary and useful improvements and retain the property until compensation is paid. So even though a person may have spent money improving someone else's property, the creditor won't be compensated for 100% of all the expenses, even if they were able to produce invoices for all the money spent on improving the property. This is because the improvement has to be identified as to whether it was necessary or useful or luxurious. So but what are necessary expenses? Well, these are those expenses which were necessary to preserve the property and prevent it from being destroyed. But then what are useful expenses? Well, these are those expenses which, although not necessary, nevertheless enhance the value of the property. And lastly, what are luxurious expenses? Well, these are those which add to the amenity of the property without improving its usefulness or necessarily enhancing its value. So with regard to enrichment liens, the amount of the creditor's claim is usually limited to necessary and or useful expenses. So what are the legal effects of liens? Well, a lien confers the right of the lien holder to resist the claim by the owner for the return of the object, so they can say no to returning the object to the owner. The creditor may retain possession of the thing until reimbursement has been made, and the creditor who holds possession of the property isn't entitled to use it for their own purposes and has the duty to take care of that property. Now let's talk about the termination of liens. Well, a lien lapses if the debt or obligation is terminated or fulfilled. Let's take a quick look at hypothecs by order of court. Well, if a debtor doesn't comply with the court order instructing them to pay the debt, the creditor may get a warrant of execution where the sheriff may attach goods of the debtor and sell them to pay the debt. The creditor has a preferent right in respect of the proceeds of the thing sold, and special rules relating to the execution against a family home apply.